Hello friends, in this video I'll be sharing with you how to present your arguments on the first date of admission hearing. In my last video I clarified to you that the arguing lawyer has to keep tuning his arguments, crafting his arguments or designing his arguments according to the nature of hearing. Now if you haven't watched my previous video in this series, please make it a point to go back and watch that video for a detailed understanding. But for your convenience, let me quickly recapitulate certain points in the last video. Thorough preparation is the first requirement before you stand up before the court for any kind of argument. You are expected to be thoroughly ready with the matter on any date on which it is listed. Your approach while arguing a petition before the court should be that of honesty and fairness. Your objective while arguing the petition at the initial stage of admission hearing could be number one, to have the notices of the court issued to the respondents, and number two, if necessary, to obtain interim relief such as stay or injunction or some other kind of interim relief. Next, at the initial stage of admission hearing, you are expected to quickly make out a solid points on merits, such a solid point that it shall instantly convince the court. Now, this video is about how to do exactly the last one. How to convince the court instantly that you have a prima facie case. And how will you present your arguments? So let me straightway come to the point. Always make an impactful, attention-grabbing opening. Make a powerful opening. Craft and design a powerful proposition which arises from the facts of your case and the law applicable to your case only. You have to articulate it, You need to take pains to learn to do this. And believe me, doing it is worth your time and the fees that you receive from your clients. So starting with such an impactful proposition serves two purposes. First, it quickly catches the attention of the court, and second, it makes the honorable judges begin to appreciate the case from your viewpoint. It may sometimes happen that even though the judges have read your case at their home, they may still have missed on the angle which your proposition is showing them. Opening proposition is showing them. And that's why your opening arguments should be with an impactful or attention-grabbing proposition. And I think that's the best way to start your arguments. Shall I give you a few examples? All right. This example is from a real case. But for understanding what I'll be telling you, a little background of the case, if you understand, will be good. Now suppose there is a case of a government servant who is retired from service, and his retirement benefits are not released by the government for arbitrary reasons which you have already pleaded in writing in your petition. Apart from not releasing the retirement benefits, the government has not even completed the departmental inquiry and has kept the departmental inquiry which was going on against him pending for quite a long time. Now, the inquiry officer in that department inquiry exonerated him from all the charges. Still, the disciplinary authority, that means the government, has kept it lingering and pending. I'm just giving you a few broad facts of the case, In addition, now the retired government servant is facing another hardship because his wife is suffering from cancer and he is required to incur huge amounts for her treatment. Added to that is the fact that even his provisional pension is stopped illegally by the government. The man suffered such a hardship that he had no money. He was required to even pledge his wife's ornaments and get some loan to meet everyday expenses and the expenses for her cancer treatment. Such is the pitiable situation of your client. Now, this is completely arbitrary. It's completely violative of Article 14 of the Constitution of India, and it's a clear violation of the right to live with dignity under Article 21 of the Constitution of India. Now imagine, you have filed a petition on behalf of this man, claiming various reliefs such as that of a direction to release retirement benefits, a direction to quash the pending departmental inquiry because it is hugely delayed, and a direction to release other monetary benefits and reliefs like that. How would you begin your matter? Your matter is listed before the court for the first time, and you want to make an impactful beginning, grabbing the attention of the court. How would you do that? Now, I'll give you an example, but bear in mind that I am not saying that my way is the perfect way. We are learning. I want you all, my young advocate friends, after hearing this example, to give your own impactful opening statements in the comment box of this video. I'm curious. Let's learn together. Now let me give you an example of my opening statement. How would it be? When the matter is called out, the lawyer would say, "May it please my lords, a retired government servant is before your lordships for 3 grievances. Number 1, his retirement benefits are withheld by the government for arbitrary reasons. And number 2, though he is exonerated by the inquiry officer, the government has kept the departmental inquiry lingering for a quite long time, like a hanging sword on his neck. And number 3, my lords, this is resulting in great financial hardships, disabling this man even to treat his wife's cancer. He is literally starving. And all this is violation of his fundamental rights under Articles 14 and 21 of the Constitution of India." Now again, I'm not claiming that this is the only perfect way, but this could be my way. Just for the sake of example, I'm giving it to you. I could come up with other variation of it also if I apply more thought to it. You can craft your own opening statements using your creativity and ingenuity. The important thing is you articulate your opening statement while preparing your case. And one more tip. Whatever your own opening statement you finalize, if you can't remember it, please write it down on a piece of paper and read out from it when you open your case before the court. Yes, don't hesitate doing that. In the initial years, you will have to take aid of such written propositions or written notes. But with years of practice, as you would go on becoming a veteran lawyer, a seasoned lawyer, such things will come naturally to you, even without writing, whenever you will stand before the court. The important thing you need to have is a solid mastery over the facts of your case, the law applicable to your case, and the issues involved in your matter. And you should have already contemplated on the points you have developed and pleaded in the matter. Then your creativity will flow like anything and you will enjoy the whole process. You will start to have fun out of all this, which will again propel you to improvise your work and thus keep progressing. That's a very positive circle. So you can see that the impactful beginning which you want to make should have already been pleaded as facts and circumstances in your petition. I mean, your beginning should have that foundation already laid in the body of the petition. And the purpose of this impactful beginning is to grab the attention of the court so that psychologically the judges become ready to hear further. So friends, having understood that, having understood that you have to make an impactful beginning in your case. After opening the case in this impactful way, what do you do next? You can then start taking the court at little deeper levels. You can first proceed to dig deeper into each aspect of the matter by telling the court that you would first state the basic facts of the case, and then you begin stating the basic facts of the matter. Then you delve deeper into the law applicable to your matter and the issues that arise out of all these laws and facts, and how the questions are to be answered in your favor. But see, while stating the basic facts of your case, you have to be cautious that the court's time is precious and you are not stating each and every insignificant fact, but are stating only significant and material facts. Such material facts that they will bring out the point that you are trying to make. You are expected to have already worked on your brief by burning the midnight oil the previous night. This will come with practice, and that's why this profession requires practice, and hard work. But even when you are new, you can follow these guidelines and build yourself, prepare yourself. Would you like to know another example of an impactful opening statement as it is occurring to me now? Okay, let me tell you the opening statement itself. This is again from a real case that I had argued in the court. My lords, in this case, in complete ignorance of the well-established proposition of law that when a suit of small cause nature is tried as an ordinary suit, even in contravention of the provisions of Section 16 of the Provincial Small Causes Courts Act, the decree is not nullity. The learned execution court has allowed the objection of the respondents, dismissing my execution case. Now let me share with you few background facts of this case. In that case, the situation was that the petitioner before the High Court was a lady who owned a plot of land and had built a house of 2 rooms on that plot. Her house was grabbed by her sister and her children. Her sister and her children had faced hard times in their lives, and therefore the petitioner lady had, out of compassion and kindness to her sister, allowed her sister and her children to stay in the 2 rooms which she had constructed on the plot purchased from her own hard-earned money. But over a period of time, the sister and the children were overtaken by the emotions of greed and dishonesty, and they started unlawfully claiming that house and did not give possession. Therefore, the petitioner lady filed a civil suit against her sister and children in the ordinary civil court. Now, this civil suit was not contested at all by the defendants, that means the sister and her children, and this resulted in passing a decree, ex parte decree, in favor of the petitioner lady, and the civil court directed the defendants to hand over the vacant possession of the property to the petitioner. In spite of the court's decree, when the sister and the children did not hand over the vacant possession, this lady filed an execution proceedings in the execution court for execution of the decree which was in her favor, so that she can get possession of the property. Now, when the execution proceedings were filed, the respondents, that means the defendants, appeared and filed a frivolous objection that the decree passed by the civil court was a nullity and it was not executable. That means it was no decree in the eyes of law. And the reason for doing so was that the petitioner lady, instead of filing a suit of small causes nature, filed a regular civil suit. There is a full bench judgment of one High Court, that means the MP High Court, saying that in such a situation, the decree is not nullity. The execution court, without looking into that law, which held that in such a situation, the decree passed by an ordinary civil court is not a nullity, upheld the objection of the respondent and dismissed the execution case of the petitioner lady. Therefore, having been aggrieved by the order of the execution court, the petitioner filed a writ petition. Now you know the background and the context of the matter. If you read the actual writ petition, there are many more details with which you are expected to be thoroughly ready when you stand before the court for argument. And with such thoroughness on your part, you can make an impactful beginning. Such impactful beginning catches the attention of the court. And after you have the attention of the court with such powerful beginnings, you can immediately lead the court to the basic facts of the case to show how the point that you formulated or the proposition which you argued at the beginning of the case emerges. And while doing all this, you should also be ready with whatever law that is applicable to your case. It can be bare acts, or it can be case law, or it can be any other legal material that is applicable. And with such weapons in your armory, you have to stand before the court to fight the battle. Now, after hearing the background of the case that I told you, I again would like to know from you what could be your impactful beginning in this kind of matter. Please share it in the comments box of this video. Let's make it again a learning experience. To move ahead, now normally what happens when you make such impactful beginnings and start taking the court through the cobwebs of facts and law of your case, and when the courts have a very heavy board of cases for the day before them, the judges quickly sense the merit involved in your matter and your thoroughness with the matter. They immediately start dictating the order of issuance of notices. This suffices your purpose for that particular day. In such a situation, you should stop. It is wise to stop your arguments. Of course, if you need an interim order, then you must press for it, you must pray for it. Some judges, having already been convinced of the merits of your matter and need for grant of interim relief, would grant you interim relief on their own. But some judges may not on their own grant you interim relief. But if the interim relief is necessary in such a situation, it's your duty to convince the court, to request the court that the situation requires grant of interim relief. Again, you should be thoroughly ready with what should be the interim relief for that particular situation and the convincing reasons why it should be granted, and if not granted, how your client will suffer a loss. So friends, that's how the admission hearing on the very first date when the matter is fresh may go. What happens next? Then eventually the other side will receive notices of the court. The respondents will appear and they will file their replies. Then your task is to read those replies thoroughly and understand how they have opposed and countered your case. If necessary, you have to again sit with your client for discussing with that client each and every opposing point the respondents have raised. Now, there may be opposition which is only argumentative, or there may be opposition which is seriously based on certain facts and records. If the opposition is just argumentative, you have to analyze whether the logic of their argument is right or wrong. In argumentative kind of opposition, no new facts or records are involved. So a lot of work is to be done only at your own level as an advocate or a lawyer. The client is not an expert in dealing with argumentative things, though sometimes he may also give his inputs. But when it comes to serious opposition based on new facts, you have to re-ascertain the facts from your clients. You have to recheck the records. And after analyzing each and every opposing point, you need to assess where you stand in terms of merits of your matter. You also need to consider whether you are required to file any rejoinder for countering the points raised in the reply of the respondents. If necessary, you have to file that rejoinder. So what I mean to say is that after the matter is argued for the first time and after the respondents file their reply, the texture of your arguments would change with each passing date. The next time you would stand before the court for arguing, you will also have to take into account the points of opposition raised by the respondents, and you will have to destroy them in your speech, I mean arguments before the court, so that you nullify their effect in the mind of the court. There is a real hard work involved in that process, dear friends, but the process can become enjoyable also. And that's how the case would progress. Suppose if you file rejoinder and the respondents file a reply to the rejoinder along with certain documents, then again you will have to sit down and read the whole reply filed by the respondents to your rejoinder. And again you will have to go through the same process. Over a period of time, you will have with you a big paper book of your case. And mind you, every time the case would be listed on the board, you will have to be thorough with the whole paper book for preparation of your case. And that's how the case goes on becoming heavier and heavier and heavier with passage of time. And then a stage will come when you will have to be ready for arguing the petition at the admission hearing stage as if it is listed for final hearing, even though the court has not yet admitted the case for final hearing. Mostly now it is a trend before the High Court that the cases are disposed of at admission hearing stage only. And when the pleadings are complete at the admission hearing stage itself, the courts endeavor to dispose of the petition finally at the admission stage itself without admitting and without keeping it pending for years together. So this is how the nature of hearing at admission stage goes on changing. At final hearing stage, you have to argue the matter in depth. Without that, the final hearing does not take place. So what is the biggest takeaway from today's video, my dear young advocate friends? Please tell me. I think this much is enough for today. If you have got some value from this video, please give a thumbs up in the form of your likes. And don't forget to mention in the comment box what are your biggest takeaways from this video. And also I would like to know what would be your impactful beginnings in the two examples that I gave you in this video. I'm curious to know that. Let's make it a learning platform for all the like-minded people, like-minded friends. So thanks for watching. See you in the next video. Till then, take care and bye.